Now has accessed the Calcutta High Court 2016 verdict in a similar case where the court had observed that an accused is disentitled to the liberty of bail granted earlier if the investigation in the same case had altered the offence for an aggravated crime. Tamal Saha joins us live with more details. Yes, Tamal.
Well, Anand, that is the word, disentitled. And this is the judgment. This is the Calcutta High Court 2016 case order which I have in my hand. And this order is extremely important, significant in this case, not because both the cases are extremely identical, except the fact that Vikram Chatterjee enjoys the celebrity quotient and possibly why the case has been dragged this far. And Kolkata police has not really taken any cognizable action, even after invoking section 304, which is culpable homicide not amounting to murder. Now, this case dates back to 2014. A quick background. It was an 18-year-old girl, Akhi Banerjee, who died in a car crash in Rajarhat, Kolkata, and the driver, her accomplice, Sonika Chatterjee, was initially booked under section 304A, much similar to Vikram Chatterjee's case, which is only negligence. Eventually, when charge sheet was filed in the same case, the family of the deceased moved to the magistrate and said they were not satisfied with the investigation, thus they wanted further investigation. And only after further investigation, section 304, which is culpable homicide not amounting to murder, was invoked. But by then, this accused, Sonika Chatterjee, was already granted bail, much similar to this case of Vikram Chatterjee. Now, here came the confusion whether he should be arrested or not. In 2015, the Bidhannagar police in this particular case had moved to the magistrate, asking the magistrate or praying before the magistrate the bail be cancelled. Magistrate had obliged and the bail was cancelled, and then the accused had moved to Calcutta High Court, and there where becomes this judgment extremely important. The Calcutta High Court single bench judge had referred to a Kerala High Court bench judgment in a similar case, and had also referred to a Supreme Court judgment, a law in this case, and goes on to say that in a case like this, the court observed that there is no need to pray for cancellation of bail on part of the investigating officer when he is willing to proceed against the petitioner for the offence under section 304 part 2 of the Indian Penal Code. In such a situation, it is the duty of the investigating officer to inform the court of learned magistrate of the aggravated non-bailable offence for which the investigating officer intends to proceed against the petitioner, which means the accused. Under the facts and circumstances of the present case, the investigating officer could have, informed learned magistrate of aggravated non-bailable offence punishable under section 304 part 2 of Indian Penal Code, along with a prayer for issuance of direction to the petitioner to pray for bail for the offence under section 304 part 2 of IPC. And the last concluding part of this judgment is extremely significant. The court had observed the learned Registrar General is requested to circulate the copy of this judgment to all courts of learned judicial magistrates and additional chief judicial magistrates and learned chief judicial magistrates of West Bengal and Andaman and Nicobar Islands for favour of information and guidance. So, Anand, it basically goes on to say that this, in a way, is binding on the investigating officer, and that the investigating officer, after invoking section 304, should simply move to the magistrate and pray before the magistrate.
It's almost 4 days, Tamal. It's almost 4 days. 4 days that section 304 was invoked and slapped on charge because they were sure that he was speeding. What remains now is drunken driving, and that charge could not be proved because of inadequate blood sample to the state government. What is the investigating officer doing? What is the police station in charge and the senior officer doing? If they are they not aware of this judgment? Are they not aware of protocol?
Yeah. Well, Anand, we do not know whether they are aware or not, but they are expected to be aware of this judgment. And we know, as a matter of fact, that Kolkata police have sought legal advice from the Advocate General of West Bengal. Well, we are simply trying to highlight a very significant judgment of Calcutta High Court for their own pursuit, because we believe if they have...
You know what stands out, Tamal, is that if they have taken consultants, if they have sought the legal advice of the Advocate General, it should not take 4 days for the Advocate General to opine and give his opinion. And it would have, and it is on common knowledge, if we can access this judgment and we can know this here on Times Now, the investigating officer could have known too. Vikram Singh, former DGP Uttar Pradesh, with us. Sir, a Kolkata High Court verdict in 2016 says that an accused is disentitled to the liberty of bail granted earlier if investigation in the same case had altered the offence to an aggravated crime. So in the case of this man, this actor Vikram Chatterjee, the cops now believe he was speeding. They have slapped a charge of section 304 culpable homicide not amounting to murder. So does that not revoke his bail immediately? Should they not have arrested him immediately given the Calcutta High Court judgment?
They should have, but what more do you expect from a police force that is totally sold out to Didi's instructions? First, they take the samples in a quantity that is not optimum. They take the samples much after the time lapse. Now they seem to be fumbling like what you have said, three blind men, and they need to be coached and tutored in the basics and rudiments of law. Come on now, Kolkata police is one of the most professional police forces. They could give a tutorial or two to you and me. But today, if they choose to be blind and oblivious to important case laws and important facts of law, I would probably feel that they have been compromised, their professionalism has been compromised, and don't expect much against Vikram Chatterjee from them, because obviously Vikram Chatterjee is the blue-eyed boy of Didi, and therefore he will come to no harm.
Well, I don't know, because Mamata Banerjee said that she wants impartial probe. It was after her intervention that the four-member SIT was formed. So one wonders what is stopping the investigating officer or who at the ground level, because there was a certain level of political influence and also some big powerful people, influential people who are trying to scuttle this entire probe and bury this entire matter. Were they involved? Are they influencing and putting pressure? We don't know, Mr. Vikram Singh. I thank you for talking to us. Ashok Vishwanathan also with us, filmmaker. Ashok, now this is another aspect that comes to the fore. There is a 2016 judgment of the Calcutta High Court which says that an accused is disentitled to bail if the cops aggravate the charge. They slap a far more serious charge on him. So then by that count, Vikram Chatterjee should be behind bars.
Absolutely. I think the police has botched up this case from the very beginning, and I suspect that the powers that be have pressurized the police into doing that. As you said rightly, that now that they've framed additional charges, the more serious charge, which is not amounting to homicide but culpable all the same, they should have arrested him immediately. But he's still out on bail. The charges are not being framed. And the Calcutta police is doing this repeatedly from case to case. We find there's a delay in framing charges. There's a delay in accepting FIRs. The total confidence level of the people in the Calcutta police will go if this continues in this manner. Despite the Chief Minister's assurances, nobody seems to be acting on it. Where is the action taken? This is reprehensible, I feel.
And do you not believe that an issue like this, a Calcutta High Court judgment like this, will not be available or will not be known to the investigating officer? And will it take 4 days for them to figure life out?
No, they've deliberately done it because they are under influence. There's some important producer and maybe someone in the ministry has been muscling around, using his muscles. These political goons are the ones who really call the shots, and justice is denied. Justice delayed is justice denied.
Absolutely, but we will not allow that to happen. Justice for Sonika Chauhan is a campaign here, and we'll continue to follow this story. Ashok Vishwanathan, thank you for speaking to us. Going back to Tamal, Tamal, have you been able to reach out to the investigating officer, the top cops? Because there are a certain few in the Kolkata police who want justice to be delivered. There are those who don't want to succumb to this political pressure and they want the truth to come out. What are they saying? Why are they quiet?
Anand, the question is how long can they afford to be quiet, because after invoking section 304, they have to now justify their action as under what circumstances, on what ground did they invoke a fresh charge of section 304. And if they have solid evidence in their hand, what is making them sit like a sitting duck on this case and not take any cognizable action? We do not know whether Vikram Chatterjee is guilty or not. That is the job of the cops to prove, and that to the court of the law. But we are trying to say is after you have invoked section 304, why are you giving this leeway to somebody who is known to be a celebrity, who had held a press conference and given himself a clean sheet, and then never bothered to meet with the bereaved family, asking for absolute forgiveness for what has happened?
Right.
Imagine the family is still waiting to know the truth. We do not know what the truth is, but then Vikram Chatterjee out in open, possibly that way the truth will never be known to either the family of Sonika Chauhan or to the people at large.
Tamal, thank you for the inputs.